dear participants of the conference, ladies and gentlemen, thank you to the organizers for opportunity to present you protection against violence in children's rights in regional human rights system. In this presentation, I will mention the most important elements of the topic. The published article contains many more aspects than those just presented. The violence against children includes all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse. Under international law, states have the obligation to protect children from various forms of violence. The main international human rights instrument addressing the protection of children against violence is the United Nations Convention on the Rights of the Child. The convention entered into force in September 1990 and has been ratified by 195 countries, making it the single most ratified treaty in existence. Only 2 countries in the world, the United States and Somalia, have not ratified the convention. This presentation analyzes the specific types of violence against children and the response of the major regional human rights systems, the African, the Inter-American, and the European human rights system. Regarding corporal punishment in schools, regional human rights systems had different regulations of use of corporal punishment in schools. Under international human rights law, the practice of corporal punishment breaches 3 of the most basic human rights principles: the right to human dignity, physical integrity, and to equal protection under the law. States have an obligation to enact legislation to prohibit corporal punishment. The African human rights system also explicitly bans school corporal punishment of children. In the United States legal system, however, corporal punishment in schools is legal in all states. As all European countries have ratified the convention and have subsequently implemented legislation prohibiting school corporal punishment, presently school corporal punishment is illegal in every European country. Regarding sexual abuse of children, the sexual abuse of children is a serious worldwide public health concern. It is estimated that the prevalence of child sexual abuse range from 8 and 31% of girls and 3 and 17% of boys internationally. The World Health Organization defines child sexual abuse as the involvement of a child in sexual activities that he or she does not fully comprehend, is unable to give informed consent to, or for which the child is not developmentally prepared and cannot give consent, or that violates the laws or social taboos of society. The main legal instrument in the European Union law is Directive 2011/93 on combating sexual child abuse, sexual exploitation, and children and child pornography, and the Convention 201/2007, protection of children against sexual exploitation and sexual abuse. In South Africa, the most important legislation addressing the sexual abuse of children is the Sexual Offences Act. The United States also criminalizes the sexual abuse of a minor through this federal law. Regarding domestic violence, the domestic abuse is a simultaneous attack of children's and women's human rights. Domestic violence denies children the right for a safe and stable home environment. Studies have estimated that between 3 and 10 million children are exposed to domestic violence each year. The main human instruments protecting children from domestic violence in Europe are the United Nations Convention on the Rights of the Child and the Istanbul Convention. In the United States, the main federal laws that protect violence against women are the Violence Against Women Act and the Adoption and Safe Families Act. The Violence Against Women Act provides support services for battered women, better law enforcement, and prosecution of cases involving domestic violence. However, the Act has little reference to the needs of children exposed to domestic violence. In South Africa, the main laws that protect victims of domestic violence are the Constitution and the Domestic Violence Act of 1998. Regarding protection orders, court can issue protective orders prohibiting a batterer from approaching the adult victim and the children at various locations, such as the home, the victim's workplace, or the children's schools. If a batterer violates the order, victims of domestic violence may contact the police. Protective orders can be obtained by women in all regional human rights systems. Moreover, the European Union has put in place a mechanism for the mutual recognition of protection measures. If a victim of domestic violence has a criminal protection order issued by an European Union member state, the victim may request a European protection order. Also, if a victim has a civil law protection order issued in the member states of their residence, the European Union grants access to mutual direct recognition of protective measures in civil matters between member states. Regarding exploitation and forced labor, child labor is a serious issue, especially in developing countries. UNICEF estimates that almost 1 in 10 children are subjected to child labor worldwide. Africa is the regional human rights system with the highest number of child laborers. It is estimated that 72 million African children are involved in child labor. The International Labour Organization Convention on the Minimum Wage for Admission to Employment defines child labor as employment below the minimum wage as established in national legislation, as well as child labor that is considered hazardous or a part of the worst form of child labor. The two main international human rights instruments that regulate child labor are the International Labour Organization Convention on Minimum Wage and Convention on the worst forms of child labor. The first one has been ratified by all International Labour Organization members, including Africa, the second one by the majority of states. Most African countries have ratified the International Labour Organization Convention. Also, the African Constitution explicitly prohibits forced labor. The United States federal law that governs child labor is the Fair Labor Standards Act. Regarding child trafficking, the human trafficking is modern slavery in which individuals, including children, are compelled into service and exploited. Worldwide, only 0.5% of victims are identified. The issue of human trafficking is most serious in the African human rights system. It is a major region of origin for victims who are trafficked into other parts of the world, such as Western Europe. One of the main human rights instruments that regulate child trafficking is Directive 2011-36 on preventing and combating trafficking in human beings and protecting its victims, and the directive is addressed to the member states of the European Union. It provides minimum standards for preventing and combating human trafficking offenses, are high standards of protection and support to victims. Another important human rights instrument is the Palermo Protocol. In the Inter-American human rights system, the main instrument that regulates child trafficking is the Inter-American Convention on International Trafficking Minors. It requires that state parties designate one or more central authorities to oversee both criminal and civil matters related to the international traffic in minors. They must provide mutual assistance in judicial and administrative proceedings and establishing mechanisms for exchange of information. The main United States federal law that establishes human trafficking and related offenses as federal crimes is the Trafficking Victims Protection Act. The law contains provisions regarding prevention, protection, as well as prosecution. In the African human rights system, 45 states have ratified the African Charter on the Rights and Welfare of the Child. The Charter requires states to take appropriate measures to prevent abduction, the sale of or traffic of children for any purpose or in any form by any persons, including parents or legal guardians of the child. Regarding the use of child soldiers, a form of child trafficking, the use of children in armed combat is a contemporary manifestation of child trafficking. The international definition of the trafficking of child soldiers involves three necessary elements: consent, exploitation, and movement. The international legal instrument that addresses the issue of child soldiers is the Children in Armed Conflict Protocol, an optional protocol to the Convention on the Rights of the Child. According to its provisions, the minimum age for compulsory recruitment and any recruitment by non-governmental armed groups into the armed force is 18. The protocol allows voluntary recruitment starting the age of 16. However, states have to ensure that the recruitment is generally voluntary. It is done with the consent of the parents or legal guardians. They were informed about their military duties. They provide proof of age prior to recruitment. Regarding sexual exploitation, the child sexual exploitation is a serious global issue that is becoming more and more widespread due to use of technology and internet. Modern information and communication technologies leave children increasingly vulnerable to new and evolving forms of sexual exploitation. The main legal instrument addressing the sexual exploitation of children and child pornography under United European law is Directive 2011/93. The Directive defines the term exploitation in an extensive and explicit manner, recruiting, coercing, and forcing children to participate in pornography performances or child prostitution, and profiting for them, attending pornography performances involving children, and engaging in sexual activities with a child forced into prostitution. In the United States, federal law prohibits the sexual exploitation of children, which includes employing or using children to produce sexually explicit materials. Child pornography is a serious federal crime that involves the production, distribution, importation, reception, or possession of any image of child pornography. The African Charter on the Rights and Welfare of the Child, which has been ratified by 43 states, requires states to protect children from all forms of sexual exploitation and sexual abuse, and to take preventive measures. In our conclusion, there is a high level of harmonization between regional human rights systems concerning children's rights. All of the major regional human rights systems, the African, the Inter-American, and the Council of Europe, have enacted explicit legislation to protect children's rights. The main common element between the regional human rights system legislation regarding children's rights is the United Nations Convention on the Rights of the Child, and it is the only international human rights instrument that has been ratified by all United Nations member states except the United States and Somalia. We believe the harmonization of regional approaches to children's rights will continue in the future, and it is likely that the US will also succumb to great international and national pressure to ratify the United Nations Convention on the Rights of the Child. Thank you for your attention.